Superannuation is often the second largest asset in a relationship, sometimes the largest, yet it is one of the most misunderstood parts of a property settlement. Here's what you need to know. First, can super be split after separation? Yes. Under the Family Law Act, superannuation is treated as property and can be divided between parties as part of a settlement. This applies to both married and de facto couples. The important thing to understand is that superannuation is a different type of property. It is preserved, meaning it generally cannot be paid out until you reach retirement age. So rather than receiving a cash payment, one party receives what's called a superannuation interest, which is transferred to their own super fund and preserved under the same rules. There are two main ways super can be split. The first is a superannuation splitting order, made by the court as part of consent orders or following a contested hearing. The second is a superannuation agreement, a specific type of binding financial agreement that deals only with super. Both require the fund to be formally notified and given an opportunity to respond. On whether you receive the money now, not usually. The transferred super stays in your fund and is subject to the same preservation rules that apply to all super. It can't generally be accessed until you reach your preservation age and retire. There is an exception for certain defined benefit schemes in some circumstances, but that is complex territory requiring specialist advice. Valuations matter here too. Accumulation fund balances are relatively straightforward. They are the current balance. Defined benefit funds are much more complex and require an actuary to value the entitlement properly. If the valuation is wrong, the split will be wrong. Finally, super is just one part of the broader property pool. How it is split needs to be considered alongside everything else: the family home, savings, debts, and each party's future needs. A larger super entitlement for one party does not necessarily mean they should get less of the other assets. It depends on the whole picture. If you are going through a property settlement and have not yet addressed superannuation, raise it now. Cudmore Legal, family law done properly. Call 1300 Cudmore or visit cudmorelegal.com.au.